Right. Good afternoon, everyone. I'm Carl Freitag, and today's topic is influencers, agencies, and brands, things you should know. Just in terms of a little bit of housekeeping, all videos and microphones for all attendees are turned off by default, and the webinar will be made available on YouTube in due course. Please just excuse any traffic noise that you can hear in the background. It's a rainy day in Cape Town, and we all know that that means that people suddenly forget how to drive. All right, so a little bit more about me personally. I'm an avid gamer. I play mainly first-person shooter games, arcade and strategy games, and I'm also a musician who plays guitar and sings. I'm categorically not an influencer. I think I have like 20-something followers on Instagram, and I only really use Facebook for work stuff. I think my dog has more followers on Instagram than I do. So you may be thinking, Kyle, what qualifies you to speak about this stuff at all? Well, I'll tell you. As the head of commercial law at Legalese, I regularly assist brands, agencies, and influencers with navigating the legalities around their contracts and the disputes that arise from them. I also spend an inordinate amount of time structuring and drafting contracts to house these relationships for more specific purposes. I therefore have a very in-depth understanding of those relationships and have assisted in the resolution of disputes from all sides. Brand versus agency, brand versus influencer, agency versus influencer, influencers versus the other two, you name it. So just a little bit more about Legalese. Legalese is a creative legal agency which has redesigned legal services to suit creative, startup, and tech-based businesses by making them accessible, affordable, and understandable. We take care of your business's legal needs so that you can focus on what you do best, your vision and your business. We offer user-friendly legal products and packages designed specifically for businesses that have just started, companies that are maturing, and enterprises seeking expansion and investment across all kinds of industries, from creative, tech, and startup to education, gaming, nonprofit, everybody basically. To find out more about us or to get in touch, email us at info@legalese.co.za, follow our Instagram page at Lawyers of Legalese, our Facebook page at Creative Legal Solutions, or otherwise just give us a good old-fashioned phone call at 021-422-0214. All right, so people generally don't like influencers, mainly because it seems like influencers have unlocked the secret to life, right? Or at least that's what their socials will have you believe. They actually work very hard. Those people don't believe that influencers are worthwhile. However, numbers certainly reveal this to be nothing more than jealousy and spite. So let's look a little bit more at those numbers. So influencer engagements have exploded in the past few years, both in value and in number, and it's growing all the time. In 2021 alone, influencer marketing is expected to be worth $13.8 billion. Yes, that's billion with a B. Agencies and brands are capitalizing on this, with 59% of brands that were surveyed having a standalone budget for content marketing, and 75% of them intending to dedicate a budget towards influencer marketing in 2021. The question then becomes, can your brand or agency afford not to be part of the influencer movement? So our first heading that we're going to deal with today is contracts. This obviously refers generally to written agreements that record the terms applicable to the relationship between the parties to the contracts. So the topics we'll be dealing with under this heading today are the duration of the agreement and the payment dates, the relationship between the parties, obligations of the parties, exclusivity, intellectual property, content release, and content continuity provisions in contracts, restraints of trade, and then force majeure as well. So let's chat about the duration of the contracts. It seems like a really, really simple, silly thing to have a whole subsection about, but this small aspect certainly accounts for a lot of the disputes out there. It's crucial to ensure that the following dates are accounted for in your agreement. So firstly, the duration of the contract. That may be in the form of a stipulation that the contract is effective for a certain period, or otherwise it might stipulate a start and end date. Either way, these dates let the parties know that the intended dates during which the terms of the agreement will be effective and binding on them. The next date that you want recorded in the agreement is the date for performance of any of the obligations and that's for either of the parties. It's important because it lets the other party know what the expectations are that you may have in respect of that relationship. If you know when you need to do something, generally you'll do it if there are consequences for failure to do so. And also pretty much if you're getting paid to do it, you'll generally do it. It also provides an objective metric to assess whether a party has breached the agreement or not. So if somebody has breached a term of the agreement, if somebody has done something and it's not in accordance with the date that is set out for that for the performance of that obligation in the agreement, it's obvious and easy to know that that person has breached the obligation in terms of that agreement. So the third date that we need to look at here are dates for usages. These are the dates in respect of which the content created by the influencer can be used by the agency or the brand. I'll touch more on this under the intellectual property section a bit later, but for the time being, suffice it to say, it is incredibly important to establish. So next, we're going to look at the relationship between the parties. First, we're going to be looking at why is it so important to exclude certain relationships. We're then going to look at the dichotomy between independent contractors versus employees. And then we're going to look at something that I call the partnership problem. Right, so why is it so important to exclude certain relationships? So contracts are all about setting up relationships and making sure that the parties to those relationships perform in accordance with those terms. So why is it so important to exclude certain types of those relationships? Well, when you create certain relationships, for example, an employment relationship where you have an employer on the one hand and an employee on the other, certain rights are associated with those relationships by operation of law. So going back to my employment example that I mentioned earlier, creating an employment relationship affords the employee certain rights, like those contained in the Labor Relations and Basic Conditions of Employment Acts. Those may be inconvenient in the context of a relationship between a brand, agency, and influencer, and it is therefore certainly not desirable to find yourself in one of those relationships. So let's look at the difference now between an independent contractor and an employee. So in general, the path of least resistance when it comes to engaging an influencer or being engaged as an influencer is to set up an independent contractor relationship. This briefly means that party A, the influencer, is being engaged by party B, the agency or brand, to perform certain services or provide certain deliverables. For example, the content creation and social media posts that the influencer needs to make for a specified period or the duration of the contract. This differs from an employment relationship in that the manner and hours of work in which the influencer works is not subject to the control or direction of another person. The influencer does not form part of the agency or brand's organization. The influencer is not economically dependent on other parties for the services that they render, and the influencer is allowed to perform services for other people. We'll touch a little bit more on exclusivity in a little bit. For those of you who are shouting at me saying, oh, but Kyle, the influencer might not be able to perform services for other people, we'll touch on that. So now let's turn to what I'm calling the partnership problem. So it's very, very easy and convenient, and it's widely, it's quite a ubiquitously used term especially in the influencer and agency and brand ecosystem. It's easy to refer to somebody that you're contracting with as a partner, because that's what you're doing, right? You're partnering with somebody to do something for you. However, caution should be used when using that term in a contractual context. In South African law, the term partner implies the creation of a relationship which is not dissimilar to a marriage relationship. I know that sounds ridiculous, but the estates of the partners are linked, and if one partner is liquidated or sequestrated, the estates of all the partners follow suit. This is obviously highly undesirable, and all of my past clients in the audience will have been told something similar in the past. I'm perhaps a little bit overcautious about it, but I never use the term partner in my agreements unless I'm specifically excluding a partnership relationship. It's that bad, and I do it for the reasons that I've mentioned already. So this is an easy one, folks, turning to the obligations of the parties. How is somebody supposed to know what they're supposed to do and by when if it's not set out in the contract? A very important contractual principle is the principle of clarity. Provisions in agreements that are unclear or vague can potentially be set aside by a court. If you're reading a contract, the consideration to take into account in determining whether a provision is vague or not is to ask yourself whether an objective person reading the contract for the first time would be able to know when and how a party is supposed to do something. Simply put, all the clauses in the contract must be clear or what we call reasonably ascertainable. That means it's either stated in the contract outright, or it's easy to calculate or find the answer to the question that is posed there. So, as I said earlier, we'll touch a little bit on exclusivity. Something that needs to be considered by all parties is whether the services that the influencer provides will be exclusive in nature or not. For those not aware, exclusivity refers to the situation where a party is contractually bound not to perform any of the same services for any third parties for a specified period. For brands, this is something quite important, but for influencers, it is a potential inconvenience that could potentially stop them from working or plying their trade. So it's a very, very important consideration for everybody to get correct, and for everybody to just know exactly what they are and are not allowed to do off the back of an engagement. So in this regard, it's important to understand that exclusivity can also take many forms. You can, for example, have category exclusivity, which stops the influencer from performing services to third parties in the same product category as the product that they're advertising. For example, alcohol brands, apparel, motor vehicles, etc. Another option is competitive exclusivity, which stops the influencer from providing services to competing companies either specifically listed in the agreement or generally referred to. So what you can see from this is that exclusivity can take several different forms, and it's quite a malleable aspect to get to take into account when you are negotiating this this aspect of the agreement. So what you need to do there is just ensure that you are covered. If you're a brand, you need to ensure that you are covered from your client's perspective, where your client might be insisting that influencer doesn't engage with anybody in their category. For example, in the alcohol category, you can even get as specific as telling them they can't, telling the influencer that they can't engage with spirit alcohol companies as opposed to beer and cider brands, for example. You can get that specific about it, and it is something that you can regulate quite appropriately in your contracts. So next, I would imagine that this is the section that is the main reason for a lot of you being in attendance today. And there's a lot to consider here, so let's dive straight in. We're going to cover what exactly intellectual property is. We're going to cover who owns the work that is created. We're going to cover content releases, content continuity, and also we'll touch on likeness rights. So what exactly is intellectual property? Intellectual property, or IP, refers to a category of property that includes incorporeal creations of the human intellect and mind. Put simply, it's property that is created by the human mind that you can't see, touch, or smell, but that is nevertheless real and capable of being exploited commercially or financially. So turning to who owns the work that is created. There is a de facto position in the law that the person creating the work automatically becomes the owner of the creation. However, there are certain exceptions to this rule that are created by the Copyright Act, such as authors who write in accordance with their employment. For example, people who are employed by newspapers or any other periodical publications. The other exception is creators whose works are created in accordance with a contract of service. The Copyright Act expressly creates these exceptions to the rule, and influencers and creators would likely fall into the latter exception category, those whose works are created in accordance with a contract of service. However, as always, the law is dragging its heels in keeping up with the times, and this is despite the increasing prevalences of the abuses in relation to social media. Right, so let's talk a little bit about content release. As I said, the Copyright Act generally imputes ownership to the party that creates it, unless it's created in terms of a contract of service. I also mentioned that generally influencers and content creators would fall into that exception. However, in the case of agencies especially, it is sometimes necessary to have documentary evidence of the fact that the agent, the influencer has released the rights to that content. For example, where you as the agency are engaging the influencer to create content for your brand clients, and the IP needs to flow through to, the ownership over the IP needs to flow through to your brand client from the influencer. In those circumstances, a content release clause in the contract, or even a content release contract itself, is the appropriate mechanism to achieve that. All right. So in relation to content continuity, what is not immediately clear is whether that contract of service aspect or that exception in the Copyright Act applies to social media content that remains on the influencer's profile in perpetuity. So we advise that our clients take the safe route of agreeing to certain usage periods during which the brand or agency can exploit that content, or you can also agree to certain specific usages for the content, or a combination of those two. It's also advisable to agree that the influencer will not delete such content from their social media pages for a certain period. We'll just let the fire engine go past. You guys okay? Good go? Nice. All right, so let's turn a little bit to likeness rights. So the law relating to likeness rights in South Africa is relatively arcane, but it's certainly recognized. In the Supreme Court of Appeal case known as Grutter versus Lombard, the court recognized an image as an aspect of personality which demands protection. That was confirmed in Wells versus Atoll Media. What all this fancy legal speak basically means for you is that a person's likeness and image is capable of being legally protected. And their rights in that regard are also capable of being legally enforced. As a result, it's advisable to obtain a release of those rights when you're exploiting somebody's image, especially in circumstances where you're going to be drawing a commercial benefit from that exploitation. Some other considerations that we're going to deal with today are force majeure, regulatory considerations, and then labor rights. All right, so let's talk a little bit about force majeure. So COVID-19 made force majeure a very, very popular Google search term for a little while. What it basically refers to is a circumstance that renders performance by one or both of the parties in terms of the contract objectively impossible. A great example of this was the lockdown. So unless your services were capable of being performed at home, it was literally illegal for you to perform them elsewhere unless you're an essential worker. No fancy beach shots if you're an influencer, nothing like that. We weren't even allowed on the beach without getting chased by the law. So a force majeure clause in a contract provides that in the circumstances of a force majeure event, like for example, the lockdown, and also the force majeure events are usually listed in a contract, and failure to perform as a result of those events is not deemed to be a breach of the contract. So I have two little tips here that I have set forth for you guys. Tip number one, make sure your force majeure clause lists epidemic, pandemic, and other widespread diseases or some similar wording so that it can take into account the pandemic and the COVID-19 lockdowns or anything like that that are implemented, or anything like that they might have in store for us in the future. I'm sure you're as excited as I am to find out what those might be. The second tip that I have is that your force majeure clause should specify that if the force majeure event continues for a specified period, generally I suggest 30 days or longer, then there's an option by one of the parties to terminate the agreement. Generally, where there's a force majeure event, it's difficult to establish how long those things will be going on for. If you think back to the lockdown, we were all hoping that this whole thing would pass in a month, and here we are a year and a half later, and we are still under a little bit of a lockdown, basically. So the next section that I want to deal with are regulatory considerations. So if a brand that engages an influencer is in a regulated industry, for example, medicine or financial services, both the brand and the influencer need to be incredibly careful that the content created by the influencer does not constitute advice that the influencer is not qualified to give. Unless the influencer is a medical doctor, for example, they should not be giving medical advice. The influencer should also not give financial advice because you're required in terms of South African law to be appropriately qualified to do so. This is a crucial point and cannot be overstated. Be careful with what you say and how you say it. You may not be allowed to be saying the things that you're saying in your Instagram posts, and you may be providing advice that you're not entitled to provide. So just be very, very careful with that aspect. We're then going to turn a little bit to labor rights. So I've already covered the difference between an independent contractor and an employee, but I just want to restate here that setting up the relationship appropriately from a contractual perspective can release you from the requirements of the Labor Relations Act, the Basic Conditions of Employment Act, the Employment Equity Act, and all the regulations that are made in terms of those acts. If you are reckless, the person could claim that they believe the contract to be an employment contract, or that they have an expectation of continued employment with you. That is an undesirable situation that can only ever result in a dispute, because you never had the intention of setting up that relationship as an employment relationship, and you might very well find that down the road you are obliged to hire that person even though you might not want to. So what happens if we do find ourselves in a dispute? All right, so the points that I've gone through already have all been designed to get you to avoid disputes. But what happens if one arises? So the agreement that you have with your influencer or your brand or agency should contain a breach clause that sets out how a dispute is declared. Typically, but not always, the contract will stipulate that the aggrieved party, that's the party against whom the breach was committed, must give the breaching party or the person who committed the breach notice of that breach and allow them a certain amount of time within which to rectify it. Generally, that amount of time is 7 days, but it's also dependent on the nature of the breach. So if the breach is not capable of being rectified, that's also a consideration. But also if the breach is capable of being rectified, but only in a period longer than what you've stipulated in your agreement, that's also a consideration that you might need to take into account in negotiating that clause. So if after the notice that I referred to before is sent, the breaching party still hasn't remedied their breach in the stipulated amount of time, then the next stop is the dispute resolution clause. That's the clause that will set out how the dispute must be resolved and the steps that must be followed in that regard. If there's no dispute resolution clause, it's time to get in touch with a lawyer who will be able to advise you of your rights. Okay, so just to conclude a little bit about what we've already spoken about. Today, we've covered the main considerations to take into account when contracting as a brand, agency, or influencer. By necessity and due to time constraints, I haven't been able to deal with all the aspects as deeply as we'd have liked to, but please engage with us if there's specific topics you'd like to see in the future, or if you have any questions or specific instructions that you'd like for us to deal with. To reiterate our contact details, you can email us at info@legalese.co.za. You can follow our Instagram page at Lawyers of Legalese, our Facebook page at Creative Legal Solutions, or otherwise just give us a call at 021-422-0214. Thanks very much. I'll now answer some of the questions that have been raised. Naturally, due to time constraints and the sheer volume of information and knowledge that this topic requires, I might not be able to get to everybody's question, but please feel free to email us or get in touch if you have something more specific that you want an answer on. So please bear with me a little bit while I figure out Zoom and check if there's any questions that have been raised in the chat. If you do have any questions that you'd like to raise, please pop them into the chat now. Please do not use the Q&A function, rather simply use the chat and I'll engage with that. Have we not got any questions? I'll wait a little bit for some questions to come through in case somebody is furiously typing and screaming at me. Okay. I see that somebody's using the Q&A function. Let's have a look at the questions that have raised. All right, so the question that's raised here is, do the contracts have to be made legal? That is a difficult question, because all contracts have to be legal, because if they're not legal contracts, they are not, but they are not enforced legally, or the terms in relation to those contracts are not set up in a legal fashion, or there's something within those contracts that it might not be set out in accordance with how South African law would like it to be set out. Then those are issues that need to be sorted out. I note that there's a second follow-up to this question here, and they've said, we have contracts at the office, but I worry that they aren't 100%. If that's the case, the best thing to do would simply be to send me a copy of those agreements, and then we can have a look at getting those reviewed for you and making sure that if those contracts aren't 100%, we can show you exactly where they might be going wrong, or we can give you feedback on how those agreements might be improved. All right. So the next question that I have here is, can load shedding be included in a force majeure clause? Absolutely. It's a good idea, in fact, to include load shedding in a force majeure clause, specifically for brands and agencies, and in fact, specifically for agencies where content creation and delivery of the deliverables that you are creating for your clients is a consideration. You can't draft, or you can't create the assets that you're required to create without electricity. So certainly load shedding is definitely a good idea to include in a force majeure clause. All right, the next question that I've received: can you explain licensing versus ownership of IP? If you can license the IP and use this in perpetuity, does that have any structural limitations for the brand? Would this just be a commercialization limitation? All right, so a few aspects raised in that question. Firstly, can you explain licensing versus ownership of IP? Certainly. Licensing versus ownership of IP is, the difference is that in the one circumstance, the person that is creating the intellectual property retains ownership over that intellectual property and then licenses it to the other party. The other party would then, in terms of how it's agreed in the contract, that person would then be able to use that intellectual property that's created for the purposes that are stipulated in the contract. And then ownership of the IP, if it's stipulated in the contract that this person, or that you're engaging to create content for you, you're going to own that content from the beginning. That means that you own that content, it is your property, and you can do with it whatever you want. And then in terms of if we can license the IP and use it in perpetuity, does that have any structural limitations for the brand? Well, that would depend on how it's agreed in the agreement. If the limitations would be set forth in the agreement. So if we can use it for whatever we want in perpetuity, that's fine. If it does have certain limitations that are placed on it, for example, you can upload it on social media, but you can't use it if you're wanting to use it for commercial purposes, then that's a bit of a different story. But in general, the main consideration is what would be contained in the licensing portion of that contract. So you need to make sure that if there's anything that you're wanting to use that specific content for, that it goes into that contract, and that everybody knows upfront what it's going to be used for. The next question that I have here is contract work and labor law. What are some strategies to overcome renewable contracts with an agent or agency, but no formal employment, best legal limitations in SA? So strategies to overcome renewable contracts with an agent or agency. I'm not certain as to what you mean by overcome. Let me just see if I can work it out here quickly. Yeah, I'm not certain what that question entails. Perhaps the person that sent the question in can email me, and we can have a little bit more of an in-depth chat about that. The next question is: if you do not have specific information available or confirmed, such as dates, can you still proceed with contracting using terms such as "to be confirmed"? In general, yes, you can. However, as I mentioned earlier, the principle of contractual clarity suggests that you should have, as far as possible, specific dates or specific periods within which the contract is going to be effective. But if you don't have that information at hand, what you can do in the agreement is simply stipulate that those aspects will be advised by the parties in writing or agreed upon between the parties in writing. And then it can be a simple case of, hey man, you're going to be doing, we want to engage you to do a piece of content for our campaign. We don't have the specific dates, but we will advise you in writing. And then when the time comes, you can advise the other party in writing, and then come to some sort of agreement in relation to when that is going to be performed. And then then you've dealt with it in your contract, but you've sort of pushed out that obligation until the date when those dates are actually available. All right. Do we have any other questions that anybody has raised? I don't see anybody. Here's another few coming through. All right, so we had campaigns that needed to be put on hold due to COVID. We paid for the content shoots, but not for the rollout, as we had to stop the campaign. What tools can we use to work out usage fees and how much we need to be paying influencers or content creators? So again, it's a little bit, and I'm sorry that this is generally the answer, but contracts are not all created equally, and not all contracts will deal with the same things. So that would ideally be something that would have been dealt with in your contract. If I had prepared your contract, it certainly would be. In relation to COVID, the force majeure clause would kick in if you had one, and where you paid for content shoots but not for the rollout, you would have there would be. If it were me, I would put that into the court of the influencer to give you an invoice in relation to how much they need to charge. They want to charge you for those for that content usage. So yeah, that's also probably something that's quite specifically dependent on the terms of the agreement that you've got with them. And if you want to send that agreement to me so we can have a quick look at it, then sure, please do so. I see that we have a question here that says, what if we're using international influencers? Will SA law apply or another country's law? And how do I assure it's SA law which is applicable? It's a great question that I see is raised by our director, Eitan Stern. Thank you very much for that. So it's generally the law that is applicable to a contract is specified in the contract. The contract will stipulate whether South African law applies to the contract or another country's law. In general, obviously, if you're going to be providing the services in South Africa, it's nice to have South African law apply to the contract, because it's the law that is applicable in South Africa, and it's the law that we all understand. So it's a very good idea to have a look at your contract and ensure that South African law is applicable. However, if the brand that you're going to be that's going to be engaging with you wants that contract to be interpreted in accordance with like their domestic law, for example, the laws of England and Wales, or the laws of a specific state in America, they're generally the people paying the bills, and generally they get what they want. So it can be a little bit of a balancing act and a little bit of a negotiation that takes place at the beginning. But it is an important consideration, because the law doesn't deal with the same things in the same way in all countries. So it's definitely a very good consideration to take into account there. I have another contract. In other cases, use Influencer Hub to search an influencer and will give you rates based on their engagement. I think that's just a comment on one of the previous questions. Thank you very much for that. All right. I think that does it for the questions. I'm being trolled by somebody who's providing me with some really interesting other questions, but I think that should do it. If anybody's got any more serious questions, then please feel free to shoot them through. I'll give it like another minute, and then we can cut things off, and we can all have enjoy the rest of our Friday afternoon. Not all right. All right, guys. So thank you very much for the chat and the robust engagement that I've been given in relation to all the questions that everybody's provided here. I really appreciate your time, and thank you very much for joining in. If you do have any questions that we didn't cover, or that you'd like us to cover in more detail, or that you simply want to engage us on, please feel free to send through an email, and we'll engage with you appropriately. Have a wonderful day, have a great weekend, and please keep safe out there.